One teacher with a hidden camera and sinister motives betrayed the trust of 125 students. Disgraced Bloomingdale High School teacher Mark ACKETT pleaded guilty today to secretly recording his students undressing. And earlier tonight, a judge sentenced ACKETT to 15 years in prison. It was a very emotional afternoon in the courtroom as the judge heard emotional testimony from some of the students that he betrayed. Fox 13's Gloria Gomez was there.
With a hidden camera and bad intentions, disgraced high school teacher Mark ACKETT is headed to prison.
God is powerful, and I believe in forgiveness. That being said, I think he should get the maximum sentence so he can never prey on another girl again.
Last month, the Bloomingdale teacher pled guilty to secretly recording his students undressing.
How do you wish to plead?
Guilty, Your Honor.
Today, those victims who were betrayed by a teacher they trusted spoke their truth.
To Mark William ACKETT, I cannot understand how you managed to get close to all of these young women and then violate us the way you did. You not only broke our trust with you, but our trust with any male authority in our lives.
And you were the chillest teacher I knew. And now I look at you in disgust. You have caused me so much pain in the past 2 years of my life. I hope they feel the pain you have caused me and all the women, the men involved. To this day, I live with the fear of changing in dressing rooms. As there will never be an answer to why someone feels they have the right to violate another person, especially a child. I hope you get help because you need help.
Prosecutors say ACKETT secretly recorded his students changing in a storage room during his fashion design classes.
Mr. ACKETT will be entering a guilty plea to 323 counts of video voyeurism.
They say he used a cell phone and a digital camera to get video of the girls undressing. We spoke to one victim who says she had to sit there dripping with embarrassment and watch the secret videos of herself with a detective.
Really hard for me and upsetting.
I mean, were you completely nude?
Oh, most of them I had my bra and underwear on, but there was one where I had my bra off and you saw it.
Now ACKETT is going away for a long, long time. His former students left to deal with a harsh life lesson.
What I did was a violation of your privacy and a violation of your trust. I know that what I did was inexcusable and very possibly for many of you unforgivable. I ask for your forgiveness, even knowing that I do not deserve it.
Thanks, everybody. Please be seated. I think they turned the AC off, maybe, so I apologize if people are uncomfortable waiting on me. All right. Ms. Deary and Mr. Suarez, you all ready to proceed?
Yes, Your Honor.
Okay. Okay, first I obviously just want to say that this is a difficult case. No one here wins today, all right? I can't undo the wrong or fix the harm and the hurt and the suffering that's been caused. There's so much suffering in this case by so many different people and groups of people due to the actions of the defendant. There is very little that I can say today to make any of that better. Certainly there's nothing that I can say or that I can do to undo anything that has happened. My job here is to apply the law, and that's what I'm here to do. I have reviewed all of the submissions, as I said previously, by both parties that were submitted to the court in advance of today, which I appreciate receiving those so that I could review them ahead of time. I've also received and reviewed the pre-sentence investigation report in this case and carefully weighed and listened to all of the testimony and evidence that was presented today during the sentencing hearing. I appreciate the comments that were made both live today and via written submission. I assure you that I reviewed each and everything that has been submitted to the court. The defendant in this case scores approximately 366 years based upon the sentencing guidelines. The defense has requested a downward departure. The state seemingly does not object to a downward departure because in its request for sentencing, the state requested that the court impose a sentence no less than 15 years, which is clearly well below the statutory guidelines. The court is required to find by a preponderance of the evidence that substantial and competent evidence exists to support a downward departure. Pursuant to Section 921.0026 of the Florida statutes, the court finds that in this case, mitigating circumstances exist to support and to warrant a downward departure. Namely, as enumerated in Section 921.0026J, defendant cooperated with the state to resolve the current offenses. As Mr. Suarez said in his closing remarks to the court, Mr. ACKETT's cooperation with law enforcement and with the state from the outset of this case matters. And the court finds that that is the basis to afford a downward departure to the defendant. Next, I turn to the Criminal Punishment Code to determine what an appropriate sentence is, since the court has decided a downward departure is appropriate under the circumstances. The Criminal Punishment Code states that the primary purpose of sentencing is to punish the offender. It notes that rehabilitation is a goal, but it is secondary to the goal of punishment. The Criminal Punishment Code further instructs that the penalty imposed at sentencing be commensurate with the severity of the offense and the circumstances of the offense. In this regard, the court has reviewed everything submitted by the defense, but including the cases cited regarding sentences received in other cases. The court has reviewed and has considered those cases. First, I wasn't the judge in those cases, and the facts and circumstances in each of those cases that I have reviewed are distinguishable from the facts here. It is clear here that the criminal intent of the defendant was great, and that the amount of harm effectuated here was also great. The numbers that matter are the numbers that pertain and apply to the circumstances in this case. Those numbers are 125 victims, mostly minors, 323 counts, criminal acts that were effectuated over the course of approximately 20 months, on 3 different devices with 4 different camera positions. Most importantly, this case is set apart from others because the crimes here were committed by a teacher in a position of great trust and authority. The court heard and listened carefully about all of the good the defendant has done in his life and in the community and how highly regarded he is. But he used the trust that he earned in the position that he earned to violate the victims. The defendant was tasked in his position as a teacher to protect the children and to promote their best interest. Instead, he preyed upon them. These children deserve better. Their parents deserve better. Quite frankly, the public deserves better. Mr. ACKETT must be sentenced accordingly. I am pronouncing the sentence of Mr. ACKETT as follows. I believe I have already adjudicated him guilty as of the time of the open plea, at the time the court accepted his plea. In case 18 CF 13676, the court sentences the defendant to 15 years Florida State Prison, count 1. All remaining second-degree felony counts, the court sentences the defendant to 15 years sex offender probation, consecutive to count 1 and consecutive to each other. The court sentences the defendant in that case on the third-degree felony to 5 years sex offender probation, consecutive to all other counts. In case 19 CF 3914, the court sentences the defendant on count 1 to a concurrent 15 years Florida State Prison. All remaining second-degree felonies, the court sentences the defendant to 15 years sex offender probation, consecutive to count 1 in that case, and consecutive to all counts in case 18 CF 13676. The remaining third-degree felonies in that case, the court will sentence the defendant to 5 years sex offender probation, consecutive to all other counts, and consecutive to all counts in case 18 CF 13676. The court sentence in this case, in essence, is 15 years Florida State Prison with credit for any time that you've served, followed by sex offender probation for the functional equivalent of your life. I am now going to read to you, sir, the terms and conditions of your probation. The following special conditions will be imposed as part of your probation sentence. You shall not have any contact with the victims directly or indirectly, including through a third person, for the duration of your incarceration and your probation. You shall abide by mandatory curfew from 10 p.m. to 6 a.m. You shall not live within 1,000 feet of a school, child care facility, park, or playground, regardless of whether you are on court-ordered supervision. You shall not live within 1,000 feet of a school, child care facility, park, playground, or other place where children regularly congregate as prescribed by the court. Within 30 days after release from your incarceration, you shall enroll in and thereafter remain continuously enrolled in an outpatient sex offender treatment program at your expense. You shall actively participate in the treatment program until discharged by the therapist as having successfully completed the treatment program. You shall complete the outpatient sex offender treatment program within 4 years of release from incarceration, unless additional time to complete the treatment program is recommended by the therapist and approved by the court. You shall have no contact with the victims again, directly or indirectly, including through a third person, for the duration of the sentence imposed. You shall not have contact with a child under the age of 18. The court may approve supervised contact with a child under the age of 18 if the approval is based upon a recommendation for supervised contact with a child under the age of 18 and is issued by a qualified practitioner who is basing the recommendation on a risk assessment. You shall not work for pay or as a volunteer at any school, child care facility, park, playground, pet store, library, zoo, theme park, mall, or other place where children regularly congregate. You shall not view, access, own, or possess any obscene, pornographic, or sexually stimulating visual or auditory material, including telephone, electronic media, computer programs, or computer services that are relevant to the defendant to your deviant behavior pattern. You shall not download, access, or play any location-based, altered, or virtual or actual reality game that utilizes an electronic device's global positioning system's capabilities to play and or interact within the game. You shall not download, access, or utilize social media or social networking, which is defined as web-based database communication tools that enable people to interact with each other by sharing and consuming information. You shall not access the internet or other computer services. The court may allow access only after a risk assessment is completed by a qualified practitioner who approves and implements a safety plan for the defendants accessing or using the internet or other computer services. You shall provide a specimen of blood or other approved biological specimen to the Florida Department of Law Enforcement to be registered with the DNA Databank. You shall make restitution to the victims for all necessary medical and related professional services related to physical, psychiatric, and psychological care. You shall submit to warrantless searches by a community control or probation officer of your person, residence, or vehicle. As part of your treatment program, you shall participate at least annually in polygraph examinations to obtain information necessary for risk management and treatment, and to reduce your denial mechanisms. All polygraph examinations must be conducted by a polygrapher certified to conduct post-conviction polygraph examinations on sex offenders and shall be paid by the defendant. The results of the polygraph examination shall not be used as evidence in court to prove that a violation of community supervision has occurred. You shall be electronically monitored when deemed necessary by the community control or probation officer and his or her supervisor and ordered by the court at the recommendation of the Department of Corrections. You shall not visit schools, child care facilities, parks, playgrounds, or other locations ordered by the court without prior approval of your probation officer. You shall not distribute candy or other items to children on Halloween. Wear a Santa Claus costume or other costume to appeal to children on or preceding Christmas. Wear an Easter Bunny costume to appeal to children on or preceding Easter. Entertain at children's parties or wear a clown costume without prior approval from the court. You shall not possess a prescription drug as defined in Florida Statute 499-00343 for purposes of treating erectile dysfunction. You shall pay a surcharge of $151 for the Rape Crisis Program Trust Fund. You shall pay costs in an amount to be set by the court. You shall pay an additional court cost of $151 pursuant to Florida statute for crimes against minors. You shall pay cost of prosecution in the amount of $150. You shall pay the cost of investigation in the amount of $130 to the Hillsborough County Sheriff's Office. You shall present yourself for random testing for the presence of drugs and/or alcohol at the request of your probation officer. You shall not reside with any person under the age of 18 unless authorized by the sentencing court. You shall perform 50 hours of community service to be completed within the first 5 years of supervision at a minimum rate of, let's say, 5 hours per month. You shall forfeit to law enforcement all evidence seized during the investigation of this case. You shall be deemed a sexual offender and shall fulfill all requirements of Florida Statute 943.0435. You shall report as required by Statute 943.0435, subsection 2, Florida statutes, within 48 hours of your release from incarceration. This offense is a sexually violent offense under Florida Statute 394.910 to .931 Florida statutes regarding involuntary civil commitment of sexually violent predators. You will be considered for involuntary civil commitment as a sexually violent predator before release from any Florida state prison sentence that you serve. The defendant understands and agrees that the state may pursue any legal action against the defendant for involuntary civil commitment as a sexually violent predator at the discretion of the state and in accordance with governing Florida law. This does not prohibit, restrict, or otherwise limit the ability of the state to seek an involuntary civil commitment against you. I am going to impose all mandatory court costs, all costs of supervision, which I order not be taken out of the bond. And you have 30 days, sir, to appeal the legality of the sentence. As I said, you'll have credit for any time that you have served, and you'll be taken into custody at this time. Anything else for the defendant, Mr. Suarez? Anything from the state? Thank you all.
Motherfuckers.